Hi, I'm attorney Casey Walker. This video is to discuss preparing for a BVA hearing. A BVA hearing is a request to see an administrative judge following an adverse or non-satisfactory decision from the Department of Veteran Affairs. So once you get your day in court, you're eventually going to be scheduled with a hearing before an administrative judge known as a board judge. How do you prepare for that? That's the point of today's discussion. Things you need to be aware of, things that you need to consider, and what you can do to improve your chances of a favorable board hearing experience. Let's say you're representing yourself. So a lot of times we get calls from people who aren't even our clients saying, how do I dress for the board hearing? You're going to dress casually. Just put jeans, t-shirt. I mean, don't show up like you're going to the beach with like a bikini on or something, but like just be casual. Jeans, t-shirts, perfectly fine. Come as you are to the board hearing and you should have no issue at all. When you go to the board hearing, you need to be prepared to discuss substantive things. Well, what's a substantive issue? Well, you need to know the issues that are on appeal to begin with. But if you're already service connected with PTSD and you're not happy with the 30% evaluation they gave you, that might be the issue on appeal. Well, prepare discussion points on why you believe the 30% evaluation isn't valid. You're not going to discuss service connection because that ship already sailed. They already awarded service connection in this example. You're only going to discuss the symptoms that you have for PTSD in this example because that's the legal issue before the judge. They don't care about service connections. They already have it. You need to show them that you have social and occupational impairment that's far worse than the 30% the VA awarded. Or perhaps you were awarded a 10% evaluation for right knee arthritis. And maybe you have instability, maybe you have severe limitation of motion. Be prepared to highlight for the judge why you believe the 10% is inadequate for the right knee arthritic condition. The point I'm trying to hammer home here is you need to be prepared to discuss the legal issue, which is the exact issue that you're requesting the board hearing for. Let's say the VA dated your effective date back to March of 2021, but you had an intent to file you submitted in October of 2020. So the VA, you're suggesting or arguing, would be that they needed to date their effective date back to the October of 2020 effective date. The legal issue there would be the effective date, not the evaluation, if you're happy with the evaluation. I'm trying to give a bunch of examples here, but you need to be prepared to discuss the legal issues. In order to discuss the legal issues, you need to know the legal issues. So try to keep a copy of the notice of disagreement form that you submitted requesting the hearing and submitting the appeal that you submitted, and that should help you hone in on the legal issues. A lot of times what we'll do, it's going to be, I don't think difficult, but if you're representing yourself, it becomes a little more challenging because it's not just Q&A where you have an attorney or a representative asking you a question and then you just respond to the question. Instead, you have to present. So we find just a basic outline with bullet points of what the points you want to make sure you hit with the examiner and just kind of have it in front of you. You're going to be on a video camera. So prepare an outline and that'll help you hit the issues and the points you want to bring up with the judge. Keep in mind, you're there for testimony. You're not a medical expert, so you're not going there to diagnose yourself. You're going there to provide testimony about your symptoms and about your experiences. That's the point of the hearing, is to provide testimony. So if you're representing yourself and you have your little outline, Your Honor, I'm going to discuss the severity of my back symptoms now. I have had profound back problems for years. I can barely bend over to pick a pencil up off the ground. I lay in bed for no more than 2 hours and I have to sit in a chair because my back's so bad, it's debilitating. That's testimony. So that's what you need to prepare to give. You need to prepare to just discuss the symptoms and nature of your claim and the issues that you're presenting to the judge. Another consideration for a board hearing is, should I bring someone else to testify? That's entirely your decision. Keep in mind, if you bring someone to testify, they'll have to be sworn into the record. So when you do a board hearing, the very first thing the judge is going to do, off record, which means they haven't started the camera yet, is they're going to narrow down and make sure that you are on the same page with the judges to the legal issues for today's hearing. At that same time, if you bring Joe Schmo with you and Joe Schmo is going to testify on your behalf, you'll want to tell the judge that before you go on record, which means he hits the record button. So you're talking to the judge, you're on a video camera with a monitor, and you just tell the judge, this individual is going to go on record because they have something to say about my condition or whatever it might be. And what the judge will do is they'll have you raise your right hand, they'll have the other individual raise your right hand, and they'll swear you in. So if you believe you have other people who could testify or give probative or competent evidence on the record, then yeah, absolutely, you should invite them to do that. So one increasingly frustrating thing we're seeing with these board hearings is they're electronic now. Following COVID pandemic, but they decided to do more virtual hearings, and they've always had a virtual aspect, but now they're doing them almost entirely to where you do your appeal at your home, on your phone, in front of a computer monitor. Whatever platform you're using, it's digital. And a lot of times there's some veterans who might be a little bit older, not quite as familiar with the technology. This is just common. Test your equipment. Before you go on for the day of the hearing, the clerk of the judge, known as a hearing coordinator, should send you an email with a link to test your equipment. If you don't have that link, you're not doing the hearing at all, because that same link includes the access to the hearing plus the test portal.
Hey everybody, this is Shauna. I just wanted to explain what you're seeing on screen now. I've clicked on that test portal and you just follow along the prompts.
Your video and audio. Count out loud from 1 to 3 now.
You'll hear that following prompt giving you an opportunity to respond.
1, 2, 3.
There is a delay. It's a little bit awkward. After the test is completed, you will see this.
If you have technical issues, check your settings or contact your administrator.
There you have it. Now you kind of know what to expect.
So before you even have the hearing, you need that email, because that's how you're going to access the hearing. But before you access the hearing, the point here is make sure you test your equipment. Make sure the audio is good. Make sure the video is good. Make sure you know how to navigate the audio and video. If you're not good with technology, it's probably best to have someone nearby who could assist you in the hearing in case you have technical difficulties, which are common. The judges have technical difficulties. The veterans have technical difficulties. The attorneys and representative have technical difficulties. The important thing is not whether you're going to have technical difficulties, it's knowing how to respond and making sure your equipment's working. So test your equipment. So let's say you're in the hearing and everything freezes and you see the judge's face and you can see your face, but everything's frozen. There's no audio. Everything's done. What you're going to do usually in that situation is you're going to just close out that window. You're going to use the same link that you used before, and you're going to go back into the hearing through the same portal and hope that it works when you go back in. If you perpetually are striking out after about 5 or 10 minutes of attempting that, maybe you want to try getting off of your Wi-Fi and using your cell service on your phone. Perhaps you want to get off your computer and use your iPhone or your Android phone. But if after 5 or 10 minutes, switch it up, because you don't want to be waiting for another year for the hearing to be rescheduled, which is to my next point. If for some reason you have technical difficulties and they can't be corrected during the hearing, what's going to happen is the board judge is going to send a communication out rescheduling that hearing, and that usually kicks a can down the road 6 months to a year. So that's why I'm impressing upon you to be prepared for these technical challenges, and just to make sure that you have basic equipment up and running on the day of the hearing. Because you don't want to wait an additional 6 months to a year because your phone wasn't working that day. Make sure your phone's charged. Make sure your laptop is charged on the day of the hearing. If you have a laptop that loses its battery power quickly, make sure you have access to power and that it'll stay plugged in. I've had people try to do hearings from their computers in their car when their laptops die because they don't have a good laptop battery. It's a common thing. So make sure that all these things are checked and double checked before you go on to the hearing. Well, that's about it. Those are many of the considerations to prepare for the hearing. Once a hearing's done, you're waiting for a hearing transcript. That can take about 6 months to a year. Sometimes it's faster, sometimes it's a little bit longer. After the board judge receives the transcript, which is just the testimony and documentation record, and it's placed in the file, usually the judge is tasked to decide the case. And it's usually another 2 or 3 months following the transcript being placed in the record that the judge will decide the case. Assuming you have remands or favorable decisions, the VA has to receive that judge's order and then they have to execute it. That too can take anywhere from 1 to 6 months. I mean, there's no such thing as a specific timeline in the VA world, but that's a ballpark average. It's probably no more than 6 months. The VA usually executes a board judge's decision. Your appeal options and all, that's a discussion for another day. The point of this discussion was to prepare you for BVA hearings. I hope you found this helpful. If you did, like and subscribe to the channel. Thanks for watching.